Most people think asking for a lawyer once is enough. Then they spend hours in an interrogation room while detectives push them to talk. The truth about this matter is simple. Your rights can disappear if you don't make them unmistakably clear. Let's break down how this actually happens. The first step to exercising your right is to use the magic sentence every single time. When you're facing police questioning, clarity is your shield. You need to say this exact phrase: I am invoking my Fifth and Sixth Amendment rights. I want a lawyer present before any questioning. I will not speak further. Say it loud, slow, and if possible on video. Why does this specific wording matter so much? Well, it's simple. Because courts have repeatedly held that ambiguous invocations don't trigger constitutional protection. In Davis v. United States back in 1994, the Supreme Court ruled that when a suspect said, "Maybe I should talk to a lawyer," that wasn't clear enough. The court decided police don't have to stop questioning unless the request is unambiguous. Statements like, "I think I need a lawyer," or "Should I get a lawyer?" give officers legal cover to continue interrogating you. But when you explicitly invoke both your Fifth Amendment right to remain silent and your Sixth Amendment right to counsel, you create an unambiguous record. Courts love this exact wording because it's impossible to misinterpret or claim later that you were just thinking out loud. Another tip is to become a broken record if they keep talking. After you invoke, officers will often keep asking questions. They'll try the friendly approach, the aggressive approach, the "we're just having a conversation" approach. Your response to every single thing they say must be identical. Lawyer. I want a lawyer. I'm not talking without my lawyer. Nothing else. Not yes, not no, not okay, not small talk about the weather or sports or how long this is taking. This is critical because prosecutors will argue in court that you waived your rights if you answer even one substantive question after invoking. The legal standard for waiver is whether you knowingly and voluntarily gave up your rights. So every time you respond to their questions, you're giving them ammunition to claim you changed your mind about wanting counsel. But if your only words are requesting an attorney, there's no waiver argument they can make. You're not being rude, you're being legally precise. Miranda v. Arizona established that once you invoke, all questioning must cease unless you initiate further communication. By limiting your words to repeating your request for counsel, you make it impossible for them to claim you reinitiated the conversation. The next tip is to document who's violating your rights. Ask for each detective's business card or write down badge numbers if you can see them. If they refuse to identify themselves, say this out loud: "For the record, the officers are refusing to identify themselves after I invoked my right to counsel." This often makes them back off immediately because they know you're creating a record that could be used against them in court. Here's why this works on multiple levels. First, it signals you're informed about your rights and willing to fight back legally, which makes officers more cautious about violations. Second, it creates evidence for your attorney to use when filing a motion to suppress any statements you made. Under Edwards v. Arizona, once you invoke your right to counsel, police cannot reinitiate interrogation unless your attorney is present. If they do, any statements you make must be suppressed as evidence, but you need to prove the violation occurred. Having names, badge numbers, and a verbal statement about their refusal to stop gives your defense attorney concrete facts to work with. Third, prosecution has to prove you waived your rights through your conduct, which is much harder when you've clearly invoked and refused to sign anything. Another tip is to use physical positioning to your advantage. This might sound unusual, but defense lawyers teach this technique, and it's simple. Physically turn your chair to face the wall or corner of the room. Just rotate your body away from the detectives. This does several things simultaneously. It's a clear physical manifestation that you're done communicating, making it harder for them to claim later that you seemed willing to talk. It also disrupts their ability to use body language tactics like leaning in, making sustained eye contact, or using hand gestures to create rapport. Interrogation training teaches officers to break down psychological barriers through positioning and proximity. When you remove yourself from that dynamic by literally facing away, you take back control of the space. It also helps you resist the psychological pressure to respond when someone is speaking directly to you because you're not even looking at them anymore. The next tip is to invoke in writing if they give you a statement form. Sometimes they'll hand you a blank form and ask you to write out your version of events. At the top of any written statement, write exactly this: "I have invoked my right to counsel on this date and time, and I refuse to make any statement without my attorney." Then stop writing, put the pen down, push the paper away. Written statements are incredibly damaging because you can't explain context, tone gets lost, and prosecutors will read your words in the worst possible light to a jury. Even if you're trying to explain your innocence, you'll make mistakes that get used against you. Every criminal defense attorney will tell you that written statements create far more problems than they solve. So by documenting your invocation at the top of the page, you create evidence of the violation if they pressured you to write after you invoked. You're also protecting yourself from claims that you voluntarily decided to provide a statement because you've explicitly stated the opposite. Another tip is to demand to speak to a supervisor. After you've invoked multiple times and they're still questioning you, escalate by saying, "I've asked for a lawyer multiple times. I now demand to speak to your supervisor because my constitutional rights are being violated." Use those exact words. Constitutional rights are being violated. Supervisors hate civil rights complaints. They create paperwork, internal investigations, potential civil liability, and disciplinary issues. Watch commanders and sergeants also know that rights violations can torpedo entire cases. So when you explicitly frame the situation as a constitutional violation and demand supervisory involvement, you're threatening to escalate beyond just the detectives in the room. Often this will end the interrogation immediately because they don't want their supervisor coming in and finding them actively violating clearly invoked rights. And if the supervisor does come in and allows it to continue, you've now got a higher-ranking officer implicated in the violation, which strengthens any civil lawsuit you might file under 42 U.S.C. Section 1983 for deprivation of rights under color of law. The next tip you can use is simply to call their bluff on warrants and threats. They'll often say things like, "We're going to get a warrant anyway," or "This will go much easier for you if you just talk to us now," or "The prosecutor will be a lot harder on you if you don't cooperate." Your calm reply to all of this: "That's fine. I'll wait for my lawyer and the warrant." These are pressure tactics designed to make you think you have something to gain by talking or something to lose by staying silent. But here's the reality. If they had enough evidence to charge you, they'd charge you. If they had enough for a warrant, they'd get it. The fact that they're trying to pressure you into talking means they need your statement to build their case. But when you calmly agree to wait for the warrant or the lawyer, you've called their bluff and removed the time pressure they're trying to create. As for it going easier if you talk, that's almost never true. Prosecutors make charging decisions based on evidence, not whether you were cooperative during interrogation. In fact, talking often gives them additional charges, like making false statements to the police. Another thing you should note is, don't believe they can't get you a lawyer until tomorrow. If they say, "We can't get you a lawyer until tomorrow," or "The public defender's office is closed," or "You'll have to wait until morning," that's a lie in almost every U.S. jurisdiction for felonies and serious misdemeanors. Public defenders are on call 24 hours a day, 7 days a week in most counties. So when you tell you to wait, keep repeating that they keep you in the holding cell until a lawyer arrives. Until then, you're not talking. This lie works because people don't know the system and get desperate while sitting in custody. They think maybe if they just answer a few questions, they can go home faster. But Minnick v. Mississippi established that once you invoke your right to counsel, you cannot be questioned again until an attorney is actually present, not just available in the morning. The time delay is intentional psychological pressure. By insisting they hold you until counsel arrives, you're forcing them to either provide the attorney you've requested or stop the interrogation entirely. You're also creating a clear timeline of how long they held you without counsel after your invocation, which matters if your lawyer files a suppression motion. The next tip is key to saving you a lot of time while in the interrogation room, and it's this: use any phone in the interview room immediately. If they put you in an interview room with a phone, use it right away. Call any lawyer you know, even if it goes to voicemail. Call a family member who can contact a lawyer for you. Once an attorney is officially requested through that call, police interference becomes a much bigger violation. This is based on Minnick v. Mississippi, where the Supreme Court held that after you've invoked your right to counsel, police can't come back and question you again, even after you've spoken with an attorney, unless your attorney is actually present during the new interrogation. Making that phone call does several things. It creates documentation that you requested counsel at a specific time. It gets family members or attorneys mobilized on your behalf. And it makes any subsequent interrogation without counsel present a clear-cut violation rather than an ambiguous situation. Defense attorneys can pull phone records showing you called a lawyer or someone to get you a lawyer at a specific time, then show that officers questioned you afterward anyway. The next tip is to stay silent even during booking. Beyond the formal interrogation, officers will try to chat you up during booking, during transport, or while you're sitting and holding. They'll make small talk, comment on your tattoos, ask about your family, and mention the charges casually. Every word you say can and will be used against you. In fact, officers are trained to build rapport during these informal moments because people let their guard down. Miranda rights only apply during custodial interrogation, which means when a reasonable person wouldn't feel free to leave, and they're asking you questions likely to elicit an incriminating response. But courts define interrogation broadly to include anything the officer should know is likely to produce an incriminating response. Even casual conversation can qualify. Your safest approach is silence unless you're giving basic biographical information required for booking. Don't explain where you were, who you were with, what you were doing, or why you think you're there. Just repeat that you're invoking your rights and won't speak without your attorney. Next, know when Miranda doesn't apply at all. Your Miranda rights only kick in during custodial interrogation. They don't apply during traffic stops unless you're arrested, during voluntary conversations where you're free to leave, or during emergencies under the public safety exception from New York versus Quarles. If an officer approaches you on the street and starts asking questions and you're not in custody, Miranda doesn't protect you yet, but you still have the right to leave. Say, "Am I free to go?" If they say yes, leave. If they say no, you're in custody and should invoke your rights. If they're vague, say, "I need to speak to my lawyer before answering any questions." Understanding these boundaries matters because people often think they have to answer police questions in any context. You don't. Even during a traffic stop, you only have to provide your license, registration, and proof of insurance. You don't have to answer, "Where are you coming from?" or "Where are you headed?" or "Have you been drinking?" These questions are designed to develop probable cause for arrest or search. A polite, "I'd prefer not to answer questions," protects you without escalating the situation. Another tip, request body camera and dash camera footage through your attorney. Modern police interactions are often recorded on body cameras and dash cameras. This footage can prove officers continued questioning you after you invoked your rights, or that they used coercive tactics, or that they denied your request for counsel. But you need to preserve this evidence quickly because retention policies vary. Some jurisdictions delete footage after 30 or 60 days unless it's flagged as evidence. Your attorney can file requests and subpoenas for this footage immediately after your arrest. So tell your lawyer exactly when and where the interaction occurred so they can identify the correct officers in footage. According to Innocence Project data, unrecorded interrogations increase false confession risks by 34%, which means recorded interrogations are actually in your interest when they show rights violations. That footage becomes the most powerful evidence in a suppression hearing, where the judge decides whether your statements can be used at trial. The next tip here is to understand the difference between Fifth and Sixth Amendment rights. Knowing this can save you a lot of trouble. Your Fifth Amendment right to remain silent applies from the moment of custodial interrogation. Your Sixth Amendment right to counsel attaches once formal charges are filed. Before charges, you're invoking your Fifth Amendment right to have an attorney present during questioning. And after charges are filed, the Sixth Amendment guarantees you the right to counsel for that specific charged offense. So why does this distinction matter? Well, it's because the protections work differently. Under the Fifth Amendment and Miranda, if you invoke your right to counsel, the police must stop questioning you entirely. But they can try again after 14 days have passed if you've been released from custody, or they can question you about a completely different crime. Under the Sixth Amendment, once charges are filed for a specific offense, police cannot question you about that charged offense without your attorney present, period. They can't even try again in 2 weeks. This is why officers sometimes try to question you about uncharged conduct, because your Sixth Amendment right hasn't attached to those potential charges yet. Another tip I have for you is to never try to talk your way out of an arrest. This is one of the biggest mistakes people make. They think that if they just explain the misunderstanding or provide their alibi right now, the officer will let them go. It almost never works. By the time officers are arresting you, they've made their decision. Anything you say is just giving them additional evidence. Your explanation gets locked in before you know what evidence they have. And if any details are wrong or you misremember something under stress, prosecutors use those inconsistencies to call you a liar. The best time to present your defense is after you've consulted with an attorney who can investigate what evidence exists, interview witnesses, review police reports, and craft a strategy. Your lawyer can present exculpatory evidence to prosecutors before charges are filed or to the grand jury if applicable. But once you've talked to police without counsel, you've lost control of your narrative. Very often, defense attorneys report that their client's biggest mistake was talking to police before the lawyer arrived. One tip that I believe is very important is to recognize and resist false evidence ploys. Police can lie to you during interrogation. They can say your fingerprints were found at the scene, your DNA matched, witnesses identified you, or your co-defendant already confessed and blamed you. These are legal interrogation tactics under Frazier versus Cupp, and they're designed to make you think the case against you is overwhelming, so you'll confess and get ahead of it. The way to resist this is to remember that if the evidence were truly that strong, they wouldn't need your confession. They'd charge you based on the evidence. The fact that they're trying to convince you that the evidence is overwhelming means they need your statement to strengthen a weak case. Don't try to explain away the false evidence by saying how your fingerprints might have gotten there innocently, or how the witness must be mistaken. Just invoke your rights and stay silent. Your attorney can challenge the actual evidence later, but you can't unring the bell of a confession. The next tip is to protect yourself during field sobriety tests and breath tests. For DWI cases specifically, several states, including New York, recognize a limited right to consult with counsel before deciding whether to take a chemical test. This isn't the same as your Miranda right to have counsel present during interrogation. It's a separate right based on the significant consequences of refusing or failing the test. If you're facing a DWI stop, you can request to speak with an attorney before deciding whether to submit to testing. Officers will pressure you heavily on this because they have limited time to conduct the test, and implied consent laws mean refusing has automatic license suspension consequences. But in jurisdictions that recognize this right, they must provide you a reasonable opportunity to contact counsel. This doesn't mean they have to wait hours, but they can't deny the request entirely. So know your state's specific laws here because they vary significantly. Some states provide no right to counsel before testing, while others require officers to inform you of the right. The next tip I have for you is document everything immediately after the encounter. As soon as you're able, write down everything that happened, exact times, what you said, what officers said, their names and badge numbers, who witnessed the interaction, and what physical actions occurred. Your memory will fade quickly, especially under the stress and trauma of arrest. So these contemporaneous notes become critical evidence when your attorney challenges the interrogation. Include specific details like Detective Johnson kept asking questions for approximately 45 minutes after I said I wanted a lawyer at 3:15 p.m. Or Officer Smith told me I couldn't call anyone until I answered his questions. Your attorney will use these details when cross-examining officers at the suppression hearing. Officers often testify that you never clearly invoked your rights, or that questioning stopped immediately after invocation. So your detailed notes, written while the memory is fresh, contradict that testimony. Another helpful tip is to seek civil remedies for rights violations. If police violated your clearly invoked rights, and that violation caused harm like a false confession, wrongful arrest, or wrongful conviction, you may have grounds for a civil rights lawsuit under 42 U.S.C. Section 1983. These lawsuits allow you to sue individual officers and police departments for violating your constitutional rights under color of law. To succeed in a Section 1983 claim, you need to prove the officers knew or should have known they were violating your clearly established rights. This is why invoking your rights unambiguously and repeatedly is so important. It makes the violation obvious. You also need to show that you suffered damages like lost income, emotional distress, or harm to your reputation. Organizations like the ACLU provide free resources and can sometimes help identify attorneys who handle these cases. Even if you're ultimately convicted of a crime, you can still pursue civil remedies for the constitutional violations that occurred during your arrest and interrogation. The last tip on my list, this is something you should never take for granted. Understand the consequences of false confessions. The Innocence Project reports that approximately 29% of DNA exonerations involved false confessions. People confessed to crimes they didn't commit because of psychological pressure, exhaustion, fear, promises of leniency, or threats of harsher treatment. Young people, people with intellectual disabilities, and people in mental health crisis are especially vulnerable. Once you confess, even falsely, that confession becomes the centerpiece of the prosecution's case. Juries find confessions incredibly persuasive, even when defendants later recant and explain the coercion. Judges rarely suppress confessions unless the Miranda violation is clear and egregious. So the safest protection against false confession is never making a statement in the first place. No matter how tired you are, how convincing the detective seems, or how much you think explaining will help, stay silent until your attorney arrives. Here's what you need to remember. Your constitutional rights only protect you if you assert them clearly and defend them consistently. Police rely on people not knowing these strategies, getting confused under pressure, or believing that cooperation will help them. It won't. Exercise your rights, stay silent, and wait for your attorney. That's how you protect yourself when the system fails to protect you automatically.